Okie dokie. Here we go. This is about MERS. Okay? MERS. It says MERS is an artifice and they are going to blow up. Read this carefully. Judge SCHACK knows exactly where this is going and where he's taking it. Decided on August 25th, back in 2010, but still, this is a judge that's saying all this stuff about MERS. But anyhow, it says, let me see, plaintiff against Denise Mulligan, Beverly Branch defendants is, let's see, from New York. Okay. So this is all about the MERS assignments. Okay, I don't know how many pages, but it says vice president, talking about how people assigning, instant assigning of the vice president. I got one of those guys, I think. Michael, what the heck was his name? Michael, I can't think of his name now. Blair, Michael Blair. So he's talking about the assignments, okay? I'm just going to read the highlighted parts, but let's see, they got the amended complaint. So this is the history. Okay, I'm just going to read these highlighted parts. It says, okay, all right, by MERS, let me see. It says, was drafted for the convenience of the court in establishing a chain of ownership, but actually assignment and transfer had previously occurred by, delivery. The alleged proof presented of physical delivery of the subject Mulligan mortgage is a computer printout, Exhibit G of the motion dated April 30th, 2009 from Countrywide Financial, which plaintiff counsel calls a closing loan schedule and claims. That's red. I don't know why they put that red, but then it says in blue, it says plaintiff's counsel alleges in 18 of his affirmations in support that pursuant to a charter between Mortgage Electronic Registration Inc., MERS, Decision 1 Mortgage Company, LLC, all officers of Decision 1 Mortgage Company, LLC, a member of MERS, are appointed as assistant secretaries and vice presidents of MERS, and as such are authorized to assign mortgage loans registered on the MERS system and execute documents related to the foreclosure. Then it says the so-called charter between MERS and Decision 1 was not presented to the court in any exhibits attached to the instant motion. And then it says Miss Selman assigned the subject mortgage on June 28, 2009 as Assistant Vice President of MERS, nominee for Homebridge Mortgage Bank Corp. And then 5 days later, executed an affidavit of merit as Assistant Vice President of Plaintiff of Bank New York. I observe in this decision in order at 2-1 that, okay, and then he tells what he observed. And then it says, MERS lacked the authority to assign the subject, Mulligan Mortgage, to Bank of New York, as will be explained further. And then blue again, assignment of mortgage and notes are made by either written assignment or the assigner physically delivered the mortgage and note to the assignee. Moreover, MERS lacked authority to assign the subject mortgage. The subject Decision 1 mortgage executed on October 28, 2005 by defendant Mulligan clearly state on page 1 that MERS is a separate corporation that is acting solely as nominee for lender Decision 1 and lender's successes and assigns for the purpose of recording this mortgage. MERS is the mortgage of record. Okay. It says, okay, let's see. All right, it says is a fiduciary relationship resulting from manifestation of consent by one person to another, allowing the other to act on his behalf subject to his control or consent. They must act according with the highest and truest principle of morality. Okay, so let's see. They canceled the mortgage. His conclusion. And then this is just the people talking about what they went through. Some comments. MERS smackdown. Okay, MERS.